Good evening and welcome to RFL. I'm Richard French. We're going to start tonight at the highest court in the land, Supreme Court, which is now dominated by conservatives holding a 6-3 majority over the left wing. That's ever since Coney Barrett replaced the late Ruth Bader Ginsburg. In the current session, the justices, they have just accepted the first Second Amendment case to make it to the high court in a decade. And they're also working on potential game changers on everything from dark money in politics and how companies can hide and how much and to whom they're giving to, plus cases of abortion and the death penalty. Also, a free speech case that's playing out in a Pennsylvania high school. It's on the docket. As a 14-year-old high school freshman, Brandy Levy tried out for the varsity cheerleading squad but didn't make the cut. The frustrated teen did what so many teenagers do, express themselves on social media. In her case, her anger on Snapchat, posting this message on a Saturday off school property.
I said it was F school, F cheer, F softball, F everything.
But days later, the public school told Levy she was suspended from cheerleading, even for the JV team, for a year, that for violating a code of conduct.
I feel like when I signed this code of conduct, I didn't sign away my First Amendment rights. So I feel that I should be able to say what I want out of school hours, and if it's not during a school activity. I was not directing towards any coaches. I didn't have the school's name in it. I didn't have coach's name or any teammates' names in it.
Now, 4 years later, that Snapchat post and Levy's punishment, they're at the center of a major U.S. Supreme Court case.
This is an incredibly important case for the free speech rights of young people in this country. Any speech that's controversial or could be perceived as offensive, when it happens in school, can be punished if it would cause a disruption. But that is exactly the kind of speech that we protect outside of school.
After filing suit, 2 lower federal courts ruled in Levy's favor, ordering she be allowed to rejoin her JV team. A federal appeals court affirmed the decision, saying a school's authority to enforce the rules does not apply off campus.
I wasn't happy that the school stepped outside their boundaries into my home and took disciplinary action on my daughter for something that happened on a weekend in my time.
But the Mahanoy School District, which declined the news request for comment, argued in court documents that the First Amendment is not a territorial straitjacket that forces schools to ignore speech that disrupts the school environment just because students launch that speech from 5 feet outside the schoolhouse gate. School leaders also arguing this could impact efforts to protect kids from cyberbullying.
This case is so important because it has implications not just for school leaders in Pennsylvania, but across the nation to be able to provide for the safety and welfare of students in their schools.
And for more, let's bring in our first guest to discuss. Garrett Epps. He's a professor of constitutional law at the University of Baltimore. He's also contributing editor at The Atlantic. Garrett, always appreciate the time. Before I get into some of the specific cases on the docket for the High Court, we're going to learn a lot about the court, aren't we? Because while everybody surmised about the new makeup of the court and everything, there are some key tests to see just how far they're willing to go. We learned a little bit by the cases they've chosen to take, but nonetheless, this is really the first full blush as to the new makeup of the court.
It is, Richard, but I will say there are already straws in the wind and have been really since this summer that indicate that the new majority is well aware that they no longer have to placate the Chief Justice and that they are prepared to go for some of their most serious goals in areas ranging from religion and the Constitution all the way to gun control and administrative law. So I think we should be prepared for a period of rapid change in constitutional doctrine.
Well, let's take that to the nth degree, potentially. There was a piece in the Huffington Post. I want to get your take on it, and it had to do with something that you've probably forgotten more than I'll ever know, but Article 5 convention. I know it's inside baseball to the hilt, but the argument follows, and I'll let you explain the potential consequences of this. If Republicans take back the House next November, which is highly conceivable, maybe betting money would even be there, let alone take back the Senate and eventually the White House, we could see basically a complete reinterpretation about the Constitution, the applicability, states' rights, and so much more. It started off as maybe just some, fringe idea 4 or 5 years ago, but they might really go for it here if certain things, and I know there's a lot of ifs in that scenario, but that's really where they think with this court, they could go that far.
Well, the Article 5 convention movement has been around now for at least 20 years. It is a very serious and very radical attempt, basically, to wipe out the existing Constitution and, more to the point, the judicial interpretations of it that have allowed us to have a democratic system. I think that groups like ALEC and groups affiliated with the Koch brothers have been working for quite a while to have draft articles ready if an Article 5 convention is called. I think that the problem that they face is that if we get into that Article 5 process, if they convince the Congress to call the Article 5 convention, we are then facing a period of incredible uncertainty. And I would think that the economic effects of this would be very disturbing to the major corporate donors and so forth.
Let's go to more of the here and now, Garrett. And listen, by most estimations, Citizens United took an already disfigured system as it relates to campaign finance and put it on steroids. It could actually get worse. Talk about the case before the High Court, where if people think there's no limits on money or there's no transparency, it could get even more so.
Yeah, if you go back and look at the Citizens United decision and what the court actually said, they said we are, in essence, deregulating independent expenditures by rich individuals, corporations, and unions. But they said Congress can manage it, the legislatures can manage this problem by requiring disclosure. And the case that appeared, Americans for Prosperity versus Bonto, the case that was argued earlier this week, dealt with a California statute that requires charitable organizations to file a tax form with the state that lists their donors. It seems quite possible that the justices are going to say that requiring these charities to disclose the donors, even confidentially, violates the First Amendment. And then the next case is, about super PACs and even campaign candidates, that it violates their First Amendment rights to have to tell where their money is coming from. There's clearly a good deal of sympathy for this view among the more conservative justices led by Justice Thomas. And it is something to be very concerned about.
I showed my audience before I introduced you about that free speech case. And on its face, it says, you got a kid who vented when she got home on Snapchat about not making some team. And the school said, nope, you violated your code of conduct. We'll take some punitive action. But give me, Garrett, where this is not just about a kid and whether or not she did this on school grounds or at home. Give me the application, how this could go beyond some teenager saying some four-letter words online.
Well, if the school district wins the decision they want, basically the court will have given school administrators, K through 12 school administrators, the presumptive right to control and punish any kind of speech by their students on social media anywhere in the world. Now, this would be phrased slightly differently. They're going to say, well, but it can only be done if there's disruption. So the school district in this case is asking for a fairly broad rule that really I think would be very bad news for students. On the other hand, you have some libertarian and religious groups that are picking up that they want students to be able to express themselves, that letting schools regulate what students can say off campus may impact the kind of religious expression they can engage in and so forth. So it's not clear which way the court's going to go. It's going to be a fascinating oral argument, and people who can listen to it should.
To the New York gun case, and specifically the court reconsidering what New York can and can't restrict in terms of guns if somebody has a legal permit from outside the area. I spoke about this with a leading contender to be the next DA in New York yesterday, but this has broader applications than just New York and guns. We're getting into some state rights here and the ability for municipalities to make their own regulations, and which is the superseding, in effect, right, whether it comes from outside state lines when they cross or not, right?
One of the, at least, claims of conservatism in this country is that it favors local control and states' rights and so forth. But when it comes to the Second Amendment, these same people are so aggressively nationalistic that they want, in essence, for the Second Amendment to disarm, so to speak, any state or any city from any kind of firearms regulation. This law, the concealed carry law, is in effect not just in New York, in a number of cities and states around the country, that says that you can apply for a concealed carry permit, and you have to show some reason why you need it. Remember what we've seen in the state capitol in Michigan. The idea is becoming normalized that protests, so-called, with a gun and threats with firearms, including, the most devastating sort of military weapons, are part of a citizen's rights of participation in government. And this court doesn't give me a lot of confidence that they understand the danger of what they are doing to the Constitution.
Garrett, always good picking your brain. I appreciate the time. Thank you.
It's fine. Good to talk to you.
You as well. We come back, everyone. We got big news on the COVID front. The CDC making a major announcement that'll impact just about all of us. We're also going to show you what the president had to say today about the virus and the vaccines that are fighting it.